Welcome back, and many thanks for staying with us right here on the #1 breakfast show in the world, Morning at 10 TV. Of course, let's get into the biggest conversation of the day. Retired Major Paula Awich. He is already here. You already know it's going to be a showdown. We also do have the Deputy NUP spokesperson, that is Mr. Alex Waiswa Mufombiro. He's already here with me. And we want to talk about the issues that are taking center stage within the country. First of all, we want to go and interrogate the chaos surrounding the Mitana Municipality MP, that is Mr. Francis Zake. He was booted from the Parliamentary Commission, that is on Thursday last week, for disparaging the Deputy Speaker, Anita Among. Now, they also want him to actually give them some kind of apology for those actions. But then he says, I cannot apologize. You've already punished me by removing me as a commissioner. Why are you telling me to actually apologize? It doesn't make any sense. And even the vote was passed without quorum. 155 of the MPs actually did get involved in the casting of those votes. But we do have 529 MPs, excluding ex-officios. So it was passed without quorum. What does that mean? That Mr. Francis Zake was removed illegally. So what will be the next, reaction for the members of the National Unity Platform? When we did talk to the Secretary General, Rubongoya, he said they're going to leave that position vacant. They're not going to send any other person to fill that vacancy. Of course, we did talk to Chris Obore about the effect of that, and he said, according to the rules, yes, they can continue with an empty vacancy. So that is a conversation we're going to be expounding on the issue of people being kidnapped left, right, and center. The journalists at Alternative Digital TV on Thursday last week who were rounded up. We're talking about Mr. Norman Tumuhimbise and 8 others. 6 of whom were released on Wednesday. It was actually Tuesday, so 3 more are still there. We are talking about Arnold Mukose, Bikobere Farida, and also Norman Tumuhimbise, the main man there. So is kidnap a form of arrest? Why are we kidnapping people and then they are showing up in courts of law? Shouldn't we be, investigating and then we summon these individuals? So we do have a lawyer, Paula Awich, so he shall be making sense of that. He is also the Director for Diaspora Affairs at the NRM Secretariat. Very good morning, gentlemen. Mr. Paula Awich and also Waiswa Mufombiro.
Good morning.
Good morning, my brother.
So many issues I want us to discuss, but let's kick off with the main issue. Mitana Municipality MP, Francis Zake, he was booted from the commission, that is as of Thursday last week, but they still want him to apologize. Bring us up to speed with the latest details surrounding this case. Waiswa.
Well, waking up in the morning today and you're going to discuss the mighty Honorable Zake, instead of the soaring prices of soap, instead of the soaring prices of sugar. But that is what the Parliament of Uganda and the administration of the Deputy Speaker decided to give priority. They gave priority to a squibble fight with no facts.
I see.
And you see, they dented the entire legal process and regime of Parliament. Parliament is a creation of the doctrine of separation of power, which brings in the real principles of the legislature, the judiciary, and of course the executive. The main role of Parliament is to do an oversight role over government in terms of accountability, but also allocation of resources, because they are in charge with making sure that as the legislative arm of government, they also look into the policies and budget framework before it is passed. They look at the projection of the promises to Ugandans and how much it can be realized. So a commission is what manages the welfare of members of Parliament. He had to also even the ministers, because ministers are members of Parliament. The only independent budget from that which is not of the commission in public administration, in political administration, executive and the legislature is only different from the office of the president. All the rest are remunerated, arising from the discussions and the formation and understanding of the parliamentary commission. Now, Honorable Zake was our eyes on ears alert on ensuring that the projection of Ugandans, we have been having a very long, there has been a story always. Every parliament that has been presided over has always gone with the trend of increasing their salaries, They have gone to the trend of increasing their fuel, their cars. You have been hearing all this. Now, all this happens in the commission. So it was with the wisdom of the Honorable Robert Kyagulanyi and members of the National Unity Platform that the person who is going to go into that commission must be a person with full understanding of the reality we are facing as Ugandans, not only to appetize and massage the interests of colleagues in Parliament. Because as I said, that is where salaries are increased, that is where all that is done. And for the last 9 months, there has not been not even noise that there will be salary to be increased. For us as members of the National Unity Platform, we credit that to Zake because he was given the role of making sure that they don't prioritize themselves with egocentrism, but they look at the plight of the Ugandans. So we give him a plus to that. That is why we do believe up to now that he was the right candidate. He is the right candidate to represent who we are. Others might find him like he has been persecuted by the NRA regime for the last about 4 years. You know that he was beaten in Arua, he was attacked in Kayunga when he went for elections. When he gave out food, he was also attacked. So you wonder, even in Parliament where he has been given a duty to serve, he is being politically persecuted. Why is he being politically persecuted, if I may say? One, the history of the commission and the character of the deputy speaker against Honorable Zake, even when there was no admissible evidence against him. Major here is a lawyer. In criminal law, the balance of probabilities for one to be found guilty, it is on reasonable doubt. If there is an ounce of reasonable doubt, a person cannot be found guilty because the evidence that was brought against Honorable Zake, the main witness to this evidence was the Uganda Communications Commission, because they had to prove that there is actually a person who did a tweet and that person is the person of Zake. UCC sent them to the Silicon Valley. They never wrote a letter to Silicon Valley. They never inquired from there in Facebook, because UCC said they do not have the power. One, Facebook was switched off in Uganda. Yes. There is no way, there is no legal regime that would proceed to charge someone of an offense which is by decree. There is no existentiality of that social media platform. So it is hogwash for one to believe that they can import jurisdiction to Parliament of a matter that was outside Parliament. The reason why the Honorable Sejirinya, the Honorable Alan Sewanyana, tortured as they may have been, are not tried by the disciplinary committee of Honorable Abdu Katuntu is because their matters are criminal in nature and do not, as alleged, and do not give jurisdiction and mandate to the disciplinary committee. Does Honorable Zake, even if the tweet was right, yes, it was not in the business of Parliament. The existence of the disciplinary committee of Honorable Abdu Katuntu to Parliament is it is disciplinary and rules committee. It is supposed to enforce the rules of a member of Parliament in the precincts of Parliament, because a member of Parliament in the precincts of Parliament is deemed to be immune from his actions and his words. I see. Now, as a result of that immunity, the only veil they would have had to have that member of Parliament challenged in character, behavior and in word is by instituting an internal mechanism of checking them, and that is the disciplinary committee. So it is foolhardy for the regime and for Parliament and for that committee to assume powers that actually it does not have.
So you believe this is a witch hunt? It is,
as I gave you the history of what has happened to Zake. I told you, even when he decided to do something humanitarian, there was a COVID crisis. The government of the Republic of Uganda proved that it could not manage the COVID crisis. It could not give people even the money that they had promised to them. The Honorable Zake A leader of Mityana sat down, planned for his people, and delivered food. That cost him nearly his life. The magistrate in court said that Zake was not supposed to be in court. He was supposed to be in hospital. He had been delivered by members of security. Now, if you look at the pattern in law, there's what we call circumstantial evidence or collaborative evidence. A repeated trend of occurrences will give you what the modus operandi of the other side is thinking about this particular person. So for me, I think that this is political persecution. It is total witch hunt, and it is a systematic disabuse of the NRA from the reality that there are new people on the block that are running to make Uganda a better country. First, you know, they said we were hooligans. They are only realizing later that we are actually anchored on reality, and we have the people power that we have been talking about.
That is the deputy spokesperson of the National Unity Platform Party, that is Mr. Alex Waiswa Mofumbiro. Let's also get some of the 2 cents from Paula Awich, that is the Diaspora Affairs Director at the NRM Secretariat. All right, thank you so much, sir, for actually joining us right here on Morning at NTV. Let's go deeper into this illegality. The fact that it was passed without quorum. You do have 529 MPs. You're going to respond as a lawyer. You do have 529 MPs within the House. Only 155 actually passed this vote. We needed at least 256 of those MPs to cast the vote. Are you in concurrence with many of the analysts that this was actually expedited as an illegality, an illegal vote, and Mr. Zake should actually continue being a commissioner?
Thank you so much. I have also had the opportunity to listen to my brother here. But I think we should really separate here issues and non-issues. In a sense that issues are matters in contention and non-issues are issues not in contention. So it is not in contention that NUP had to fill the member of the commission, and it is upon them to have chosen the person. If in their wisdom it was Zake, then be it. So we shouldn't labor to justify how or why it's there, because that is not an issue. It is not in contention at all. I think what is in contention or what is in issue now is the procedural aspects of how he was removed from the position of the commissioner. And we should take into view the fact that the law applicable to Parliament, of course, is the Constitution, and then the Parliament relevant legislations which governs Parliament, and again the parliamentary procedures, rules of procedures. Now, if somebody is aggrieved by the whole procedural aspects, then the law is self-contained in that it provides for avenues for due process. So for now, it's a little not easy to delve into the provision, because you need a statement of facts from the Parliament itself.
But what does Section 91 say at the moment? It actually is very clear
you're citing
that half of the members have to be in attendance during the casting of the vote.
Yes, you are citing provision of the quorum. But what I'm saying now is that that is just part of the facts.
I see.
Because if the matter goes further, you are going to have a whole what you call statement, a sworn statement of truth, the affidavit. You will be shocked to see that the affidavit from the other party will have 20 or 30 paragraphs.
All right.
In other words, if we discuss now without hearing the other version, we are judging them without hearing their version. You'd be shocked if, for example, the matter go to court and the other party says, like my brother said, and the other one makes a reply. You may find that they are going point by point. But the point here is, if somebody feels aggrieved that procedural aspects was defaulted or the procedural aspects was faulted, then there's due cause to that. And I don't think it is in the interest of NRM, the party that I am speaking for, that it is intent on defrauding, that is intent on twisting things, that it is intent on the person of Zake. So if anybody feels the procedural aspects was not duly followed, then let him take the other course of action, but with a clear view that as a party and with the flag bearers that we have in parliament, that is the NRM MPs, the broad concept is there is no intent to defraud, there is no intent to withstand, and we do follow the process of law, and that is the principle that we gave our representatives there. That is a principle that we give our flag bearers in parliament. If any of them thinks that the party believes in shortcuts and manipulations, then that person is holding that view on his own. Yeah.
Now, do you think it is fair that Anita Among, the person at the center of this whole fracas, was the judge and also the executioner at the end of the day? Shouldn't she have recused herself? And
maybe to add this, because as a lawyer, he can assist the populace. The doctrine of fair hearing is the cornerstone. It is the iota of the law. You cannot, like he said, that he would be of interest to know what the other party would say. They judged Honorable Zake minus according him a fair hearing. When the disciplinary committee, illegal as it was without jurisdiction of handling this matter, came to the floor of parliament, it had Honorable Zake, and its recommendations were that he be cautioned and states an apology. Despite the fact that I reject the fact that the Honorable Katunto found the prima facie case against Zake without evidence from the UCC of who owned the tweet. Now, for me, the doctrine of fair hearing, the entire parliament, despite lacking quorum, they did not accord Honorable Zake an opportunity to be heard before the 160 members of parliament. And in the law, he will tell you that rubbishes, that dustbins, whatever that was done in the House.
And of course, on this morning show, we are not only interrogating the fact that Mr. Zake is knee-deep in mire. We also have other issues, skyrocketing food prices, oil prices, and so forth. The NRM parliamentary caucus actually did meet, NRM legislators did meet actually the president to actually iron out a way forward on the same. So if the MPs are looking to the president for some kind of remedy, what is the role of the legislators, of the parliamentarians? And also the issue of torture are all going to be interrogated right here on Morning at 10 TV. But let's exhaustively, focus on the issue of Mr. Zake. The fact that, okay, this is how it all began, because I want the viewer to actually move with us in tandem. So he was tortured, Mr. Zake. But when he went to the parliamentary games, Anita Among, she actually commented and said, if you were actually really tortured, how come you went for the East Africa Parliamentary Games? So Mr. Zake also responded with a barrage of disparaging comments on other social media platforms. And allegedly. And that's where the chaos actually began. Now, the fact that the person who was disparaged, Anita Among, she had to oversee the whole process of disciplining Mr. Zake. That's where we are actually in Luganda, shining a focal lens. Mr. Awich, was that right? Procedurally right?
You are saying here that the comment was made against the person of the speaker. Oh, well, the one sitting in the chair then. And you are saying that is it fair that she should have said? You see, all this is now about the procedural aspects that we are talking about. First of all, the debate then issued. And I believe the members who held the view that it was wrong procedure for her to sit should have raised it in there. I don't know whether they did raise it. I've not had the opportunity to look at the answer. But it should have been raised in there. And even a ruling sought on to make the speaker pronounce herself on that position as a procedural objection or otherwise. But now we're talking without the facts that is.
But as a lawyer, do you think she should have recused herself?
It depends on the... You see, we're talking of different jurisdictions. If you're talking of a criminal aspect, a court per se, the standard of proof itself in courts are different from standard of these other aspects, like parliament.
I hear you.
Even then, the rules, like, for example, the rules we are talking of, the rule of natural justice, the applicability of courts of law may not be as applicable in because parliament itself, well, you see, if you're talking of that, the only option that you could have is if you argued around the non-derogability, that is slavery, torture, fair hearing, as you say, and then the four. But now, in this case,
yes, Mr. Wish,
it's all embedded in fact, if you proceed this way, then you end up to challenge the rule itself.
I see.
And in which case you may have to challenge the legality of the rule, because if the rule does not provide that it should pull out of it, then you may have to go to the challenging of the rules, the legality of the rules or the constitutionality of the rule, but not the action per se.
Indeed.
Because if it was still legitimate at the time of our sitting, then you can't do much about it.
So
then now that means then
yes,
Noop will have to go down into not only challenging the action of the speaker sitting in a matter that affects her, but challenging the rules therein that allows her to sit. And you are now bordering into areas of challenging the legality of an act or the constitutionality. But you are not going to succeed by challenging a mere isolated act.
I see. So before you interject, there's also the issue of the legality of what they did. The fact that Noop says the crime allegedly was committed outside the precincts of court. What do you have to say about that? Is Ojara Mapenduzi, the Badeg Laibi Division MP, right when he says the rules within Parliament actually follow you because you're still an MP even when you go to a bar, even when you go to a casino? So if you make disparaging comments in the casino as an MP, these rules still catch up to you. Is this the modus operandi within Parliament?
Of course, now, if you interpret that provision specifically, you need to read it again, and I wouldn't like to speculate. But the principle here is that if you feel that rule was applied wrongly, what is the remedy? If you feel that the rule does not govern me when I'm in Angenua, and it is used against my actions in Angenua, the whole thing is, how do you then go out of it? But for us to interpret the provision, whether or not, remember the principle is rules are not interpreted outside law. But in this case, if the members had to interpret it in their right forum in Parliament, then they should have raised it in there. But still now, each party will say either way. You will say, the rule does not catch me when I'm in Angenua.
Yes, I wish.
The other one will say, Ojara is saying the rule affects you. Then who is this neutral person who will tell us whether or not the rule is there? That's why I'm saying you fall back to the remedies. You fall back to the remedies which is inbuilt there.
Well,
because
so
both parties are saying
react to his submission and we put to rest this conversation.
First of all, the reason I started with the doctrine of separation of powers to give you the remedy where we shall go.
Yes, Alex.
And we have gone to court. But that does not deny us to speak about it and run away from the fact. The doctrine of fair hearing is a principle of natural justice.
So it doesn't matter if you're in Parliament.
It does not matter whether you are in Parliament, whether you are at NTV. There is a Luganda translation, if you may permit me, that says tosala gwa kawala nga tosaze gwa kalenzi. You do not literally you must listen to both the girl child and the boy child. But here the girl child presided over the prosecution. She was the complainant, she was the executioner. The girl child was still, the kawala was still the person to give and pass on judgment. That was extremely an abrogation of the laws of natural justice. Conflict of interest. Conflict of interest. It is also natural justice that if you have a conflict of interest, you cannot adjudicate it without bias once it concerns you as a person. This was a matter that concerned Honorable Anita Among. She would have waited for the return of the Honorable Jacob Olanya because matters are always stood over in Parliament. What was the rush about it? Because they went to a debate up to the wee hours of the night discussing how to mob out a commissioner who had been legitimately appointed by his party.
I want to reply to this because it has constantly come up. My brother here has constantly argued about the principle of natural justice, a fair hearing. True, it is Article 44 of the Constitution, which puts it among the non-derogatory. You can't run away from it.
Indeed.
Just like slavery, you can't. Nobody has power to make anybody slave. Not even the president to say, Tumsime or Kel or Pio is my slave. No. Now, but the danger my brother is going to is that his expansive interpretation of the non-derogatability of fair hearing.
Yes,
the gist of that is hear both sides.
Yes.
But now you're bringing
Zake
the
was not
aspect
heard.
of now you're bringing but you're not even bringing much the aspect of him not being heard. The gist of your point is the speaker removing herself. And to me,
no, there are 2 points.
And to me, if you insist on that,
there are two.
to me, if you insist on the speaker's
conflict of interest,
yes, that is a danger of over-interpreting the principle of fair hearing. The gist of the principle of fair hearing is hear the accused. And that is why if a court proceeds without hearing the other side, ex parte, and there's no proof that the party was served,
yes,
it is a nullity. Because you didn't hear. But the over-insistence
it is a nullity
on
an
ingredient, the over-insistence of an ingredient of a conflict of interest, in my opinion, is an expansive interpretation of a fair hearing. And if the other, and if the other party states otherwise, you risk losing it.
As he says,
yes.
The issue of conflict of interest actually may not even be on the outcome of presiding over that matter. The locus standi in this, as envisaged by all common law, because this must not be looked at as peculiar to Uganda. It is a standard of all common law, of which we are we subscribe to, being a former colony of the UK. I want to assure you that the issue of bias and conflict of interest, it is in its own right enough to annul what happened in Parliament. Because, as I have said, you cannot be the prosecutor, the executioner, the defender, the convener, and the judge. Even in the sound of how I have mentioned them chronologically, it sounds berserk. And that is what happened. But also, he was denied opportunity of saying anything on this matter on the floor of Parliament.
So he was booted from the commission. Now they want him to apologize. It's not going to compel Zake to apologize in this regard.
Zake will
it did happen to Ken Luchamuzi, by the way. It is in 2004.
That is IGG. That was the IGG.
2004, Ken Luchamuzi disparaged the then speaker, that is Edward Chiwanuka Sekandi. He said Chiwanuka Sekandi had actually eaten some 5 million Uganda shillings to orchestrate the removal of term limits. You understand? That actually took center stage the following year.
Which later turned out to be true.
Which turned out to be true. But then they actually went for Ken Luchamuzi for having made those disparaging comments. But then he gave a groveling apology and he was forgiven. So do you anticipate the same situation whereby Zake grovels, asks for forgiveness, and is, put back into his position?
The Honorable Zake, first of all, as I know him, he is for this country. He can never go against the people of Uganda and the oppressed. He will, of course, subject himself to no apology. And we have made it clear as members of the National Unity Platform, he still remains our commissioner as of now. And we are imploring Parliament and the Deputy Speaker not to push Parliament into a constitutional crisis, because it's not all about her. We also have the tabs, and we know what we are doing. We have been projected as novices, but this should prove to them that we are not.
All right, your last point is on this one.
No, my last point on this one is that my brother cites provisions of common law, being a member of Commonwealth, natural justice. I have insisted on Article 44, fair hearing. Now, if you cite provisions of common law, it's persuasive. It's persuasive. But the principle here is that if you have a written law against persuasive law, in this case the rule of procedure, it will be a hard nut to crack to prove that the persuasive law will stand against the written provision. If the provision of the rules of procedure is saying that the speaker can preside.
Cancel. The supreme law of Uganda is the constitution.
So you are running away from common law.
No.
I am not. I wasn't challenging you on the constitution.
Yes. So if
my reference to you was your import of the common law. And once again, I want to say that if it is a constitutional matter that you are citing, I stated by saying a non-issue and an issue.
Yes.
That one is a non-issue. If you are
when you say,
but my response to you was not on your import of the constitution. My response to you was your import
on
of
the rules.
No.
And I am saying that
your
those rules,
words, your words were common law,
yes.
and you even went further to say we are member of the Commonwealth. And that was the extent to my response.
Yes.
That if you push that and juxtapose it with a written procedure of the rules, then you won't go
now,
far.
what I want to tell you, that
Alex.
the law of Uganda is based on common law. That is very important for anybody to know. That all the laws that govern us in Uganda here are a precedent of the common law.
I see.
And that was the benchmark of our constitution, the making of
Precedents
our constitution.
are persuasive.
No. Get me right.
So.
Gentlemen, let's exhaust this conversation. I have a lot to talk about.
Now, the supreme law of the land is the constitution.
All right.
So all other laws subsequently are supposed to fall into the whims of the mother law, the constitution. So rules of parliament cannot have any power over the existentiality of our mother constitution.
I agree with you.
So for
my contention was the import of common law.
For you to say, yeah, and I have given you the background.
I agree with you there.
I have given you that even our own constitution is surely and squarely based on the existentiality of common law.
What I love about this is that you gentlemen, you both, are, big fans of the Constitution. So let's talk about the Constitution in its entirety. Human rights violations within this country. 2020, during the campaigns, we saw many of the NUP supporters being killed during the protests, others being rounded off and arrested incommunicado. We've continued to see presidents take center stage within the country. Rukira Bashaija and other people, the journalists at Alternative Digital, you understand, Thursday last week were rounded up because they authored a book that the powers that be thought the book was actually, stinging his, last 30, the last decades when he was in power. So we want to talk about human rights violations. Are we seeing rights being eroded within the country? Have we allowed that to happen? Alex Wiseworth.
It's one of the most touching
Are we
topics.
ruling this country following the rule of law or rule by decree?
We are here, we are in jungle law.
Law.
There is somebody who said that what happened, the reasons why our parents went to the bush are back. Because today I have made 36 years. It makes me as old as this regime. And I have been a scholar of the history of Uganda. And returned today, very unfortunately, that what happened 36 years, why they went to the bush has happened today. Let me tell you, the law is very clear of how you effect arrest. One, when they have opened the case against you and the reference is issued, that matter is supposed to be awarded to a person who's called an investigating officer, an IO. Now, an IO generates generates a file that is supposed to be taken to court. He follows up the matter on behalf of the state. When you're going to be arrested, after police has found that really you need to be got, when an officer comes to you, he is supposed, first of all, to show his identity card and then identify himself, state the offense you have committed, and tell the police station to where they are taking you.
Warrant of arrest.
Yes. In the event that they are coming to a village where the jurisdiction of the police is not in that area, they are mandated to inform the nearest police station and the leadership of the local government, LC1, that they will be effecting that arrest. That is the law. Those are the rules. In Uganda, it is different. They will pick you up in a drone, and they will do anything imaginable and unimaginable to you. I have been here. We have been speaking about Honorable Zake. They took him to court after torturing him with his help of COVID. And the judge, the magistrate, averred that he could not look at Zake anymore. Zake needed to be in hospital. These have happened. If I remind you, let's not even look at the politics alone, because when these things are brought out, there are those who run away from them on assumption that it happens to politicians. Kakwenza was a writer. He is a writer. He wrote whatever he may have written, right or wrong, which is his right also.
This is where the Constitution comes in.
Yes. You know what happened to Kakwenza?
Indeed.
We have been speaking about the non-derogable rights. What happened to Kakwenza is a replica of 1863 slavery.
I see.
Okay? They cut his entire back with marks, whole marks. How shall our children ever forget what happened to Kakwenza in the 21st century? You look at a gentleman called Masereka. Masereka was, they projected him to an interrogation system of waterboarding. Now that leads to death. It has been actual, because there are systems where there are forms of interrogation that have been taken off the standards all over the world, and waterboarding is one of them. I can tell you, as a member of the National Unity Platform, we cry with tears when we come and tell you that a gentleman called Yusuf Busulwa was tortured. He was a matoke vendor with his job of driving his vehicle around. They picked him from Musanji. They took him, they cut off his upper head, this upper head, they pierced his entire body. He's still alive by God's grace. There's a gentleman called Segawa. They did the same thing to him. There's a gentleman called Mugisha. They castrated him. He will never give birth to a child. A very young man. There is my sister. Yes.
During Museveni's tenure, the same president who is against torture.
During the
same president who came to power saying that he was relieving this country of all the bad deals during Amin and Obote too.
I am giving you names, and I can give
all
you.
This happened under Museveni.
Sauda Madada will never give birth. Her uterus was removed from her stomach because of the Arua incident, my brother.
What are we dealing with
Uganda?
Wisewell, when you do have a president who is so much against
the
torture?
President,
but then the foot soldiers are doing the different.
General Museveni is not against torture. Let me remind you, when he was addressing the passing of police officers in Kabari, he noted with assertion and pride that he was in fact excited by the news of how the Honorable Robert Kyagulanyi had been battered. These were his own words, and he was telling these words to security personnel that actually a person who runs against me, you are at liberty to torture them, to maim them, and these were words of the head of state. So, and he was not in a different platform. He was on a platform of passing of members of the security and police officers at it. Now, for me, it is hard. And then also, as I told you, it is important with circumstantial evidence. I heard General Museveni speak about what was going to happen in Arua. Yes, on that very rally, he said that in Bujiri, where I was arrested for a whole week, they were not that very ready against the hooligans. But in Arua, and this was his speech, Ugandans can go back and recollect.
I see.
But in Arua, he was ready for showdown, and the showdown took the life of Yasin Kauma. When we talked about it, General Museveni wrote a missive. It is on record that Yasin Kauma was a terrorist. The annoying fact is he was not. In fact, later, the very General Museveni sent 20 million shillings through Catherine Kusasira as Mabugo for murdering Yasin Kauma, a terrorist. Now, the state has a policy of not negotiating with terrorists. But here, they were sending 20 million for burial and after arrangements. It speaks to the core that the torture that is here is specifically espoused. You know, this has been spoken about by even the highest ranking members of security.
First, go back to 2018. You're telling us about that case. It is still pretty much in court up to now. It hasn't taken off in the DPP's office. So we want to know why. According to you and other NUP officials, you're saying this case might be revived ahead of 2026.
The case, you know, that case had ice cream guns.
Yes.
They presented guns that the Honorable Kyagulanyi, our generational leader and vision flag bearer, that he had imported guns to the room. Now you wonder, then his vehicle had been hit by the bulletproof vehicle of the president had been hit by a stone. Now somebody carried guns, but when he was executing a crime, he went for another option of carrying a stone. Now that entire case is a replica of the case.
Is that why it hasn't taken off?
It will never take off. There was no case. It was murder of Yasin Kauma. It was ambiguity of the regime. It was it is the NRA regime. It is the rebels in charge
continue with your
of the
submission
country.
from 2018. We are now going to the 2020 campaigns.
Now, when we come to the 2020 campaign, the most horrendous campaign the world has ever witnessed were the 2021 campaigns. Number one, look at how we were manhandled. The torture. We lost people on that campaign trail. In Mukono here, the police force is responsible for the death of over 6 people in an accident, you remember. Let me tell you, in Masaka, Frank Senteza was murdered around Busega as we were trying to bring a journalist who had been hit by a tear gas by a sound bomb, Ashraf Kasiri, to hospital for his life. God has helped that young man, though not very okay, he's still alive. I can tell you that Frank Senteza was buried in his home place in Kalungu. Now, those tears, when our fathers were lied to by bandits who went to the bush, projected that they were going to make Uganda a better country and equitable for all, they have run away from that obligation, and we, their grandchildren, as they have supposedly said, have been subjected to what our grandfathers were subjected to what inspired our fathers to give them support in the bush, to what inspired our mothers and parents to work with them. That has all gone. We have now realized that it was a group of people who are self-centered and who are with the mindset of creating Uganda as an empire.
Let's also give a chance to the Director of Diaspora Affairs, Mr. Paula Awich, to make his submission.
As I conclude, we know the people culpable to this torture. We have unequivocably been on different platforms and without fear of ever stated these people. I can state here that General Kainerugaba Muhoozi is responsible for the torture of Kakwenza, Masereka, and many people, because he takes even the cardinal principle being the commander of the land forces. The charge sheet of Kakwenza was abusing the person of the president and the person of the commander of the land forces, the first son. He also tweeted, committing himself that what had happened and they had arrested Kakwenza would not ever happen again. What happens to morality in this country?
Thank you so much. That is the Deputy NUP spokesperson, Alex Waiswe Mufumbiro, breathing fire right here on Morning at 10 TV. And of course, during the 2016 elections, what we did see within the US were disparaging comments towards Donald Trump. Even when he took over the presidency, many people wrote books, including some of his aides like John Bolton. Many other people wrote books disparaging him, but none of these people ended up in jail because they have very, a strong constitution. The First Amendment allows for freedom of speech. The Second Amendment allows for, bearing of arms.
The president was taken off Twitter.
So there we do have the hallmarks within Uganda. Paula Awich, retired major. Let's talk about what the constitution right here in Uganda says about torture, what it says about what we're talking about right now, human rights violations. Is kidnap a form of arrest? Freedom of speech?
It's not. It's not. Now, I like to start by saying that the comments my brother here makes are so injurious to the country.
Injurious to the country.
Including him, because NTV is viewed by the entire world.
Indeed.
Now, if somebody in Cambodia or in Ukraine is hearing this kind of a country which removes uterus, this kind of a country that
removes nails, whips people on the back.
It's not good, because eventually if the country gets in disrepute and damage, even him is inside. So we should be very careful to make some of these assertions with facts. For example, I would have expected that these matters had already been reported to an authority, even just for record, to say, yes, we did report this. But now you find that somebody is in ownership of these claims, which are so dangerous, it is not reported anywhere. And in this forum on the TV here, we have no time to prove that. And yet, you cannot prove it. The damage is already done to the entire country. Now, back to the issue of whether or not torture is a policy in government. I like to categorically say it is not. And remember, I'm talking as a director in the party, because the party is the one which has the contract with the people.
Indeed.
We are the ones who went and convinced people with our manifesto that vote for us, and when you vote for us, we shall do A, B, C, D, including freedom from torture, including freedom of speech. It is all contained in our manifesto. The government that is acting is an agent of the party. So the party is the one with a contract with the people.
Indeed.
So even from the party position, that is not the position, and that's not how we formed specific governments for underlying ministry. I like to say that these accusations has constantly come up, including a few weeks back that Honorable Chagulanyi went to European Parliament and made the same assertion. But I'm only lucky to say that yesterday, not yesterday, but one, I made a similar presentation in European Parliament. We put our position very, very clear to European Parliament. I'm lucky that European Parliament gave us admissibility, they locked us, the forum, and as NRM we made the presentation, and it is settled. Now, you cannot assess a country by individual acts. You assess a country by measures in place, by policies in place. So you very well know that right from the constitutional provision, Article 44 is in place. And several legislations, including the ratification of international instruments that govern these areas. I like to cite in particular the Anti-Torture Act.
Go ahead.
The Anti-Torture Act shows the commitment of the government in that in the past, if a police officer or a soldier in the course of duty causes torture, in the past, such an officer would argue the defense of Attorney General. He would say, I was doing the work, even if I castrated, like as he alleges, please don't look at me, the castrator, look at the Attorney General. The current legal regime passed by the same government that is being accused of not respecting human rights. The law says, if an officer does that, he is personally liable. So who has taken a case against an individual officer for this? And doesn't this show a commitment, the political will? If government can even surrender its officers and say, if you misbehave, please face it. This is a high level of commitment by government.
So you're saying, I want the viewer to be in tandem with this conversation.
Yes.
Let's use the example of the journalists that went to the Human Rights Office and they were whipped. So you're saying Lieutenant Colonel Namanya, made the order, please whip those journalists at the UN Human Rights Office. But then those who were actually punished were these foot soldiers, those who were given the order to go and beat, not Lieutenant Colonel Namanya. So is that what you're saying? No. That the person who gives the order is exempted, but the person who actively got involved
now, this punishment you are citing is a punishment by the authority. But I'm saying the journalist who was beaten could single out who beat him. But the punishment that you are saying was an administrative sanctions by the authority to say, for us, we don't condone it.
So even in the 2020
that is an aspect.
Even in the 2020 campaigns that saw Noob supporters being killed, you're saying it is not Muhoozi who is liable, but the soldier or officer who pulled the trigger.
No, if you portion the act of responsibility to Officer X, to Officer Y, it is you to say, my injury, my bad feeling, my heart is occasioned by you. So it doesn't matter who, but it's you to say you are the one who caused it. And government is saying, if you did it, that is it.
But who gave the person the order, which?
It is now you, the claimant, to say, I am not going to Kopol or Pio, I'm going to the one who sent appeal. It's up to you. It's up to you to say it. But the point is that the political will of government to say no longer hide under Attorney General is a big, big political will that the world should know. Now, I have already said that you assess the country by measures in place, not individual acts. Now, you can even go further to say, okay, if you claim as a government, you as a director at the movement, how do we implement these measures?
Indeed.
Because it's one thing to have measures in place and implementation. I can assure you that even the implementation is clear. I give you 2 cases.
Go ahead.
I'm giving you these 2 cases because when I made the presentation to European Parliament 2 days ago, I consulted the army and the police to say, can you prove to me that you actually punish officers who act on opposition? The army said yes. The army gave me 2 cases which were handled in open court. In one Nigeria, an officer arrested a new person. In the process of taking him to jail, he shot him. The court martial pronounced himself death. If the same thing happened in Rubaga, an officer arrested Nup demonstrators who were burning tires. They went to some garage in Rubaga. He followed there. In the process of arrest, they killed them. Now, if the army was to protect officers who act against opposition, these 2 cases court-martial would not have pronounced themselves to the point of death. Court-martial has meted punishment to officers who torture, including others of 83 years, others life imprisonment. If I had known, I would have brought you the cases, because these are cases handled in open court. So,
fair enough.
So now, if a government have measures in place from the Constitution, from ratifying international law, from passing the Anti-Torture Act, from punishing an officer who shoots a new person to death in court-martial, why don't we then say that even in process of arrest or even in process of mob handling,
yes,
there are rules of engagements given to officers in action. And these are legitimate rules of engagement arriving from procedural laws. Therefore, and we should differentiate between an act of an officer and position of the government or position of the party. And this is well clearly spelled out in the grand law, the Constitution, in the international laws adopted, in the legislation made, in the courts, in the army court-martial, which has passed death, which has passed sentences to 83 years in jail, which has passed life sentence. So there is no policy of torture. There is no policy of harassment.
Mr. Wage,
position is clear.
So you're telling us we need to change the law so that we can be able to go for the ringleaders, the people who make the orders. But the current law as it is, you're saying it goes for the person who pulled the trigger. Is that what we are getting from you?
No. I need to be clear. I said here that the person who caused your pain, it is now you.
But Nope is looking for the ringleader. Should we change the law
the pain
so that we get the commander?
No, the law is there.
No,
it is only it is abuse. The law is there. It is abuse.
Is that what we are dealing with?
In fact, in the military.
No. I have said the law is there, and I've demonstrated in length about the operation of the law, and I've taken in case the case of the army court-martial, and by the police court-martial. For example, when Besje passed in Kalerwe, there are police officers who harassed and tortured people. These police officers were arraigned in the court of Odongping. Actually, I was called as an expert opinion because I am a human rights expert. I have been with the United Nations as a human rights judge for 8 years in Geneva and Switzerland. So the police court called me to give my expert opinion on that matter. The officers who handled the case of Besje and Kalerwe were severely punished. Others were dismissed. Others were sentenced to long prison. I was there in that court. So you have both the police court and the army court martial handling cases of a discipline. How then do you turn around and say it's a policy of government?
Paula Awechi is the Director of Diaspora Affairs at the NRM Secretariat. We also do have the Deputy NUP spokesperson, Alex Waiswe-Mofumbiro. You're going to react to that submission from Paula after this short break. All right, let's take a break. We'll return shortly.
You're watching Morning at NTV.
It's a heated conversation right here within the morning at NTV studios. Even when we went for a break, we continued talking right here. And of course, Mufumbiro is here and Mr. Awich. Let's continue with this conversation because we are running out of time. Please react to what Mr. Awich was talking about, the issue of the Constitution. And also we do have civilians being tried within the General Court Martial. What does the Constitution even say about?
You see, I have spoken about Nubian Lee on many platforms. Nubian Lee is the gentleman who nominated the Honorable Kyagulanyi. And yes, he was arrested and tortured for constitutionally nominating a presidential candidate. He spent 7-8 months in prison in the General Court Martial for doing a constitutional role. That speaks to the constitutionalism of our country. And I keep wondering if in our bright minds we had not chosen another, even in fact both the one who nominated and the one who seconded first arrest in this election, because the first lady Babi Kyagulanyi was under house arrest for a part of over 4 weeks without access to food. You remember that? Now when somebody comes here and says there is remedy, it is not right. Let me tell you, Rita Nabukenya was murdered by the police. Naguru. Naguru. Where she was murdered from is a place where we have a camera of nearly 500 million. What did the police say? The cameras were not on at the time. Hakim Sekama was murdered along Bombo Road. There's nothing that happened. If you look at Waliendo, Waliendo was shot in Bujiri. There is nobody who was tried. Ask Sentongo, the officer in charge there. Frank Sentes, as I have mentioned. If you look
How
at
sure are you
Omolongo,
that the Rita Nabukenya case was not an accident?
I'm giving you because
the police told us the cameras were not working.
The police was responsible for the knock. I went there on the scene of crime. I was sent there by our team to do the analysis. It was clear-cut murder. Okay.
Do you have the evidence?
Yes, and we said if they want to rebut it, it is the police. The police has the cameras. They did the crime. Let them present the footage. They told us it was not working. In Naguru, at the headquarters of police. If cameras are not working at the headquarters of police, where are they working? Dan Cheyune, we produced a video, probably he was in the diaspora. He was shot closely as we were coming back from the burial of Rita Nabukenya. Dan Magic, you know what happened in Kayunga. These numbers, if you visited, if I went with you to our party secretariat, we have a list of people who were murdered by the regime because of their stance in politics. This is not a story. That is why we are here to discuss it. Parliament has not even come out to show any organ of government of the reality of what we faced. So you cannot seek remedy when you're dead.
Indeed.
Okay? And government must not be comfortable that there is remedy. Government should move to ensure that the laws of this country, because what is affecting this country is the longevity of the dictatorship. They want now to entrench themselves, and therefore they need to instill fear in the public. How do you instill fear? When you get a dissenting Waiswa, get him, beat him to pulp. If he's dead, you can... Chibalama is lost. Probably you help us. He's a father of 4. He disappeared 2 years now. He has never been seen anywhere.
He appeared in the hospital and he said he was okay.
Who?
He was being taken care of by the...
No, I'm not talking about Chibalama, the founder of the party. There is John Bosco Chibalama, an accountant who was picked by the military, probably since he's a former fighter and a member of the diaspora and the oligarchy, he can help us. Chibalama has never been seen. A human being got lost in Uganda under the regime of the National Resistance Army. Should we come here and macerate that? We speak for the people. The drones, the work of the drones, we never knew what drones could do. Today we talk about drones because they have been used by the state. There is a gentleman called Yusuf Kawoya. He was picked from La Bonita, you remember. Badly tortured. Where are the officers? What they do instead? They pick the NUP, and instead of charging the military, they charge NUP for putting on red. They charge NUP for putting on this beret supporters. They beat them for being supporters of the Honorable Kyagulanyi. And yet for them, even when such crimes have been committed, They will pick NUP supporters that are rotting in their jails, dress them up in their ragtagged uniform, and bring them that they are the ones who had committed the crimes. They never charge soldiers that have committed those crimes because they have deliberately been sent to commit those crimes.
That we need to set the record straight. You're telling us that when civilians are being charged within the General Court Martial, or the soldiers are being charged, they bring NUP supporters instead of the soldiers?
They array NUP supporters in. Do
you have evidence over this?
Because you have never known those soldiers and their numbers. Let them give you each soldier and their number and their face. You know how they brought them.
So when they charge a soldier, that is a NUP supporter?
It is a NUP supporter.
Who's going to be thrown to death?
Yes. No, they never throw them to death, my brother. I am telling you, I have given you the names. Has anybody been liable for Hakim Sekama's death? Has anybody been liable for the murders? He was not around.
Which is here to
just wait a minute. November 18th, 19th, 54 people were murdered on the streets of Kampala and Uganda. This is a fact attested to by the regime. They first told us that we had stray bullets. It was later proved and even noted by Enanga, the police spokesperson, that actually there were 48 people who were murdered on that day in an election period. 54 people, and yet we believe the numbers were higher. Nobody has ever been brought to book. They told us it was...
There were some two,
they told
an
us,
LDU officer and a soldier who were actually...
So you think two LDU officers who are responsible?
One LDU officer and a
we
soldier.
have a police patrol car that was commanded, patrol car number 117. Those officers, because that was the patrol that was responsible for the stray bullets and the shooting of the young girl who had picked food and was serving it around Itawa on Kampala Road. We have researched and investigated these facts. We know what they are doing. They are only creating a facade of hoodwinking Ugandans that they are actually following the law, but I'm telling you, even the people they charge, if you want to assure us that you're charging these people, there is a gentleman called Rukubasaija Kakwenza who says that the first person who was there as was being tortured was Muhoozi. Bring him to book. He does not have immunity. He doesn't have immunity over atrocities on humanity. He doesn't have that humanity. So you're saying we need to change the law so that we go for the ringleader and not the foot soldiers? The law of the military is that a commander must be a good commander. If you give bad command, you are liable. That is the law. That is why when there is abuse in administrative and the fuel and the what, they'll go for the commander. You have responsibility as a commander to give right orders, and soldiers, they follow the simple principle of command and control. They follow the orders of their commander. These atrocities have been meted on us deliberately by the regime. Probably the first dismissal. You know that they. Is that why? You know that these
cases continue coming up because we are going for the wrong people?
Even as I speak now, there are people who are being abducted. Very unfortunately.
Is that why torture has persisted? Because we are going for the wrong people. The foot soldiers are not the ringleaders.
Yes, we are going for the wrong people. But also for me, I will state it here that this torture is intended to assist the longevity of the regime that is garnered towards transitioning us to giving us their own hair without a choice as Ugandans.
Do you have evidence that the son is going to be the person in line?
But haven't you seen posters of the prince? Haven't you seen the posters?
But he says it is not going to run.
No, haven't you seen the posters of the prince? You want me to be here and lie as if I've not seen them?
Okay.
Haven't you seen people vouching
that and then
for that?
We talk to which and then we go.
The longevity of the dictatorship has to instill fear in the population. And how do you instill fear? First of all, make them hopeless. Even what they believe in should be colluded with blackmail, and then those who are standing against the blackmail, what you do? Torture them, bribe them, harass them, blackmail them, or even to the worst, kill them, and all that is on table for the national interest. But the news is
allegations.
We are not timid to those facts. The duty we are doing today is a generational calling to make sure that our country that veered off the cause of rule of law, respect for human rights, development, infrastructure, and economic transformation. We, the members of the National Unity Platform, under the able leadership of our generational leader, the Honorable Robert Chagulanyi, can promise to Ugandans that we shall liberate you, and we can tell you we shall set foot to the right trend of where our country is.
Retired Major Paula Awich, please respond to these allegations. Yes, he's breathing fire. Civilians being tried in the General Court Martial.
Yes,
so
Nubian was tried in the Court Martial.
My response is that at one point my brother lost seriousness and he tended to have been joking, especially when he mentioned that the new people are dressed, taken to court and charged as UPDF who have committed this, and that the army court asked all that time for drama. No, I've been fairly long in this army, right from NRA.
Prosecuting civilians.
I have been in this army fairly long, from NRA as a baby soldier, and I have been in transition to UPDF. I can assure you that there is no such a drama. So that's why I'm saying my brother almost degenerated to lack of seriousness.
All right.
If I say a soldier or an officer shot somebody in Wanigea and was sentenced to death by court-martial, even the police in Wanigea know that such incident happened. How do you tell me that this person who was sent to court was a new person, dressed in uniform? And no, that's not being serious. If I said something happened, if I said something happened in Rubaga, and this person, the garage is known, the people who saw the death were there. So I like to say that we really have to pull up our socks and discuss national matters seriously.
And of course, national matters, skyrocketing food prices, oil prices, and so forth. You can also give us your 2 cents on that. The MPs are looking to the president, yet they are the people speaking for the people. So who is speaking for the voiceless? We can get to that national issue.
So are we taking leave of this?
When you finish your statement.
So therefore, the issue of trials of civilians in civilian courts, in court martials, are matters of the law. Court martials as procedures. For example, you have the unit court for that case. You have a brigade court. You have a division court martial. You have the court martial, general court martial in Makinde.
Yes,
you have appeal court martial, which is presided over by a judge. So even if somebody says, I am wrongfully in this court, you have brought me to a wrong court, and that is his contestation, then you have a right of appeal to the next court. Court martial is not an end in itself. The next court of appeal of court martial is presided by a civilian. And even then, you still have the appellate level to the other civilian courts. So if you feel you are grieved by being charged in a wrong court, what's the matter about it? Exhaust the other avenues. It's not that once a new person is charged, as per what the prosecutor thinks is the law. Remember, by being drugged, if you're a civilian being found in, if say the allegation is being found in having military stores, that's a common charge. You're found with a gun, you're found with a uniform and all that. If you are drugged in court martial and your defense is, I'm in a wrong court, let the court martial pronounce itself. Said, fine, I've heard your pronouncement. Go to appeal court, which is chaired by a civilian judge. Exhaust that.
Who's the judge of the
Let
appeal?
him finish.
No, just to help the people. Who is the judge of the appeal court of the court martial?
I can't get you the name. But what I'm saying is a fact and it's a procedure of the law. The court martial, for example, the one which was chaired by General Tumine or General Guti, there is above court chaired by a civilian.
Who?
You want the name?
Yes.
I can't get it even in break time.
Yes.
But there is. But take it from me that General Tumine's court or Guti's court, there is an above court chaired by a civilian. You can appeal in there. And even then, it transitions to the ordinary court, Court of Appeal and Supreme Court. So if your defense is, I'm in a wrong court, state your defense, maintain it. But the way it is stated by our brothers is like, that is the end. You have taken Nook to court martial, that is the end. Not at all.
So, let him finish.
I was disciplined not to interfere with yours. Not that I lacked what to interfere.
Yes.
But therefore, the issue of civilians being charged in court-martial should be handled procedurally. The other aspect,
as a historical, is it right?
Go ahead, Mr.
As a historical,
Mr. Wich, we are wrapping up.
Is it right that a person who nominates a candidate is tried in the general court-martial?
Continue, Mr. Wich.
It depends on, you see,
I'm giving you Nubian Lee.
You are giving the case of Nubian Lee.
Yeah, he was arrested
and your question
for nominating a candidate
tried
in the court-martial.
The way you are stating it is like he's being charged for nominating a candidate.
Yes, that was the offense.
That is the offense?
Yes.
I need to see it again.
Go ahead,
but
Mr.
anyway, the ingredients of the offense are always demanded. And then the prosecution will prove the ingredients of those offenses. So, therefore,
therefore, Mr. Awich, therefore, let him first finish.
I think let's see.
I'm trying to get your chain of thought. Therefore,
the question of civilian charged in military courts is not an issue because there are procedural aspects to address it. The next court is a civilian, then it transitions to Court of Appeal and Supreme Court. So that shouldn't be a worry.
Right.
So Ugandans should know that justices is predominantly focused in both courts, both the police and the army.
All right,
the legal question I wanted
in
legal,
30 seconds.
Yes, legal.
30 seconds.
There is no way the existence of the general court-martial is to handle the indiscipline of the military, not of the civilians. That is the cardinal.
Your last point as to the viewers who are watching.
And most importantly, the issue of trying civilians in the court-martial has been settled by court law, by case law. In the case of Kabaziruka versus the state government, and you, our brothers who are in this.
Thank you so much, gentlemen.
Should stop running with answers that are not right in the assumption that we don't know what is true. What is true is that there is political persecution. Kanyamunyu had a gun, an illegal gun. Madada Kenya was not tried in the court-martial, but Nubian was tried in the court-martial for nominating a presidential
candidate. Gentlemen, thank you so much for having made the time to speak to us. We've actually stretched into Masuse Mutia's time, but then because this is a very, very pertinent issue. So thank you so much, Alex Weiser, and also Mr. Paula Awich,
very humble,
having made the time to speak to us. Really, thank you.